I go to dark places with judges where they're just tired of me, especially if it's a judge that doesn't want to listen to the law and the facts. I believe in the law. I believe in the system of checks and balances, and they've got a right, we've got a right. You've got to protect the system to protect us all. Know yourself, know the rules, know the judge, know the procedure. How does he or she like it done? You do something long enough, 10,000 hours, you're good at it. So I don't have much patience with someone that's not going to at least give me the respect of putting a little time. Hey, Brian Parker here with another exciting video. It's my last video on the trial I just did up in Michigan at the circuit court. Client is very happy with the outcome, and so am I. But what I wanted to end this three-part series, it's not 1, 2, 3, but this is the final video I'm doing on the trial to get you the most information and most education I can give you from both my 30 years and just this week's experience. You always learn something. If you have ever seen a circus act where the performers are twisting plates, so they've got these poles and they're spinning the plates, keeping them all up. They've got 5 to 10 poles and the plates are spinning and not one's crashing, at least hopefully. That's a trial. That is what goes on in a trial. You've got to know, you got to keep plates spinning constantly. Otherwise it falls down and the act is bad. So that's my definition of how a trial looks to me. So my job is to keep those plates spinning in the air. So I'm going to give you a couple of tips. Take it for what it's worth. Number 1 tip, know the court rules. Every state has their own court rules. They're largely based on the federal court rules with their own nuances depending on the state and the needs of the particular state or jurisdiction. But know every rule that you're going to come across in trial. I'm going to give you an example of what happened with me. I've alluded to this in my other 2 videos. I'll put it this way, it doesn't necessarily mean it's like this. I pulled a fast one on LV/NV funding. So every debt collection case, when it's tried, the debt collector, debt buyer uses 2 forms of evidence. Number 1, they put your client on the stand. They put you on the stand and then pepper you with questions about this agreement. You didn't pay. How come you didn't pay? By the way, how come you didn't pay? And just make you look bad in front of the judge or a jury. As you know from many of my videos, the ability to pay or not pay has nothing to do with the central issue is, why is this company suing my client when they don't own the debt? But they're allowed to ask, how did the agreement get started? Did you take the money? Is the money in your bank account? Why did you start? They're allowed to do that just to make you look bad in either whoever the trier of fact is, whether it's the jury or the judge. So I knew that. I knew that's their approach. And how they do that is when I'm an attorney, I represent the defendant. Defendant and I show up, and that's their first witness. They put their witness list together. I put my witness list together. I did not put my client on my witness list. They put my client on as what's called, for their purposes, an adverse witness. But I knew I wasn't going to put anything on in evidence. This was just their case. I hadn't done a counterclaim because I intended to do something else after the trial was won, and there's a risk there. But I knew if my client sat there, he was nervous, like we all would be, and I would have to spend days preparing him, and even then, he would eventually break. That's just life. So I didn't want him in front of these people, and with his permission, I played a trick on these guys. I knew that an attorney in Michigan, let me put up 2.117, Shazam, that's appearance by attorney. A party may appear in action by filing a notice of the fact that me, the attorney, is showing up. In general, an attorney may appear by an act indicating the attorney represents the party in the action. Once an attorney shows up, the person does not have to show up anymore. And I'm not presenting any evidence. I didn't put him on my witness list, so there's no reason for him to show up. I knew if he did, they'd pull him in, put him up there, and that's the start of their case. So they brought in a nice person from the actual law firm, and they also brought in another attorney to help her. So I got 2 attorneys coming after me, but I used that to my advantage. In order to get the client of mine on the witness stand, he has to be there, or they have to subpoena him to be there. They did not expect my client not to show. Had they looked at my witness list, like they should have, there's 2 attorneys plus a support staff and 3 other attorneys at this law firm. No one looked at my witness list. So had they seen that, they would have seen he's not on there. Secondly, most law firms know you subpoena the people you want to show up. They did not do that. There was all sorts of problems with the paperwork and all that, and I've gone into that. But trial work 101 is you subpoena the guys you want to show. So I told my client, with his permission, I'm not having you show. He was happy about that. So under the rules, as long as I show, that's his appearance. I'm an agent. So I go into court, I'm ready to go. They sit down, they call their first witness, and they call their first witness in a way that, oh, they already know he's not there. So they do it in a way like they're gonna default him. So the court says, where's your client? I said, you're on a 2.117. It's a very rule-based judge. Says, only I need to be here. I am not putting in any evidence. I'm just gonna refute their evidence, what there is. And the judge said, well, who's on your witness list? And I said, not my client. And they just sunk, because you're always standing, and the guy goes, this. And he goes, but I put it on my witness as an adverse witness, on my witness list. I said, he can call my client whatever he wants, but he's not on my witness list. The rules say he doesn't have to show. That was 50% of their case I just knocked out. I took a chance because the judge could have been in my face and maybe have an ego, but he doesn't. He's neutral and rule-based. I had my client in the parking lot of the court, ready to bring him in if I sense there's gonna be a problem. The judge goes, okay. And that just knocked out 50% of the case. So I knew the rules, but I would not be any good to you if I just told you it was all butterflies and roses. I also made a mistake about not knowing the rule. I pretty much assaulted their witness, killed their efforts, done everything. I did a good job, not because I'm the greatest, I'm not, but I have to work really hard to get to where I am. So I'd read everything, I knew everything. I knew their case better than they did. So, but I blew it. At the end, the judge said, gee, is there a motion you want to make, Mr. Parker? Which is him telling me, you may have a shot here at getting this kicked. So I said, yeah, I'm kicking this case, directed verdict, that's a criminal term, for under 2.116 C10, C9, I threw in C8, and those are summary disposition rules, not trial rules, to which he reminded me I had the wrong rule. But he's not a jerk about it. He says, Parker, I think you need to use 2.504, which says, in an action claim or hearing tried without a jury, after the presentation of the plaintiff's evidence, they'd done crap, the court on its own initiative may dismiss, or courts generally won't do that, or the defendant, without waiving the defendant's right to offer evidence if the motion is not granted, may move for a dismissal on the ground that the facts and the law and the plaintiff has no right to relief, which that was clear. But I said the wrong rule because I did not know. I hadn't tried a case in 6 years and I wasn't expecting them to be so bad. I kind of was. I should have known that. So if I'd known that rule, I'd done a better job. The judge did say when we finished, he goes, well, I'm gonna take this under advisement, which he said a lot, but I should have known that rule just to let him know I'm not a bad attorney, which I'm not, but know the rules, all right? I should have known that. By the way, I'm gonna attach obviously my show notes and also a checklist, a trial checklist to the video at killdead.com. Please like, love, and subscribe. Killdead.com has the great AI superpower, and I'm required to tell you that even though you may not believe in AI, it believes in you. And take it from me, who's deep in their shorts, that sounds bad. They are using AI, and it's getting really heavy out there. They're gonna be suing more and more with less employees and less information, which will be good for us, but there's gonna be a lot of lawsuits. So Parker GPT is that defense for you. Know the procedure. Deep dive in the judge, find out his likes and dislikes. As I've said in previous videos, I learned about a judge having this thing for poetry and the gray wolf. And I was at the Court of Appeals, Federal Court of Appeals, arguing a case. That's one step below the Supreme Court. And I somehow managed to bring in his love of the gray wolf into my argument. It was about home foreclosure. So it's not gonna win the case. It's a brick, it's not a wall, but I don't let anything go. I wanna know everything and every chance I got for this person that's depending on me. And if you are representing yourself, there's no greater person to represent. I used to do a lot of lemon law. You get people out of their cars, get their money back, get their attorney fees paid. And I'd be in front of a jury with lemons on my tie, because it was a lemon law case. I only had one judge say, no, no. And I had to argue the case to the jury with a shirt open and no tie. So if the judge wears a red tie, you wear a red tie. If the judge has a favorite item, hobby, or focus, maybe you want to squeeze that in. I'll tell you really quickly. Chief judge of a federal court, that means he's in charge of the whole system. He was trying one of my cases, and I learned that one of his famous heroes, I don't want to give away my kid's name, had the same name as my kid. I just happened to mention that and mention my kid. And it was like, it was an instant, oh, why did you name him that? And I said, well, of course. So yeah, I'm a kiss ass. So, but I'm doing it for them, not for me. I get to know the court staff intimately when I arrive, because that's who has the judge's ear. If you're a jerk, they'll tell the court you're a jerk. So I am polite. I'm myself, to be honest with you. I like to know about people and learn about them and their likes and dislikes. And this old courtroom was straight out of To Kill a Mockingbird. It had balconies. It was from the 1800s. And I admired the courtroom, and I told them that. Well, that's where they live and play and work. So in a sense, you're honoring and respecting where they work, and they've got lots of stories to tell you. So that gave me a connection. I was just learning. So know the staff, get to know them, but know the case better than anyone in the courtroom, including the judge, because it will become apparent to a court who knows their stuff, just the way it is. And if you are that beacon, he needs to know more about the file. Is he gonna look at these guys that need 2 attorneys to screw in a light bulb? Or do they look at me who's quoting this and quoting that without even looking at stuff? By the way, I don't have a photographic memory, I don't think. I just read and read and read. So this thing I quote all the time: if you know the enemy and know yourself, you need not fear the result of 100 battles. Know that freaking person over there and that case better than they know it. If you can correct them on something and the judge hears it, you become that beacon of expertise. I see it all the time. I sit in front of judges or panels of 3 attorneys that go, well, Parker, you're the expert in the room. Hello. And now I know I'm one step ahead from my client. I also, when I say know yourself, this is gonna sound weird, I did a lot of trials, and back in the old days when I was younger and intense, I had to win it, and it gave me OCD, it gave me germophobia, it gave me all these, which I found out later is all trauma-related stuff from when I was young, but maybe that's what attracts trial attorneys, is the need to be authorized or validated. And I did it so much, I got OCD. I don't know if that's the way to put it. And I remember this one time I was in trial, and it was they did their opening statement. Court said, Mr. Parker, your opening statement. And in my head, I'm like going 1, 2, 3, 1, 2, 3, 1, 2, 3, 4, 1, 2, 3. And I refused to leave my seat until I had done this thing that I said I needed to do, or the world would end. And the court's like, Mr. Parker, Mr. Parker. And it took me like a minute to get this done so I could get up. Yeah, that's how nuts some people in the work. And trial work does that to you. It makes you have to be a crazy person to want to do public speaking. I love it. But know yourself, fix that problem. And I say that because that is anxiety and nervousness based. I want to win. I fear that someone's not going to approve of me. I've got 6 or 12 people in the jury box, all saying I'm the worst or I'm the best, depending on how they rule on the evidence. That's how trial attorneys think. But we all feel anxiety and nervousness, and it brings out our trauma when we're in these nervous situations. So know yourself, get rid of that. But I'm gonna give you a tip and you can take it or not, but it works for me, and I'm the most messed up person you're probably gonna know, unless you know other trial attorneys. Preparation. I focus even the OCD into knowing every single word, every single document. Why? Because the nervousness and anxiety goes away. It completely turns around where you're like, I want to get this done. I want to show that whatever your rationale, that will set you free. And now I can't wait to get to court. Come on, let's get this thing started. It's a true feeling, but my resolution of my problems was knowing the case, knowing it well. I prepare and know everything. When I talk to the court, I see the document in front of me and I talk with the document. Sometimes the judge will go, what are you looking at? And I go, oh, and that's why your trial notebook is good. A trial notebook is what you need. I want your whole case, their case and yours, starting at the answer all the way to the final trial brief. Whatever it is that you think is going to win your case, beat a witness, or beat them, should be in a trial book. You do not want disorganization when you are standing there and the judge wants an answer right away. I do not depend on my trial notebook. I do not live in my book, but it is there when I need it. Sometimes I'm taking it out and giving it to the other side. I think you meant Exhibit 7, and that pays off in front of the jury. It's like, oh, this guy, he's the expert. So that will, number one, get rid of your nervousness and anxiety. Preparation and a trial notebook. I'm going to tell you, don't completely depend on that, because at the end of the day, that preparation will make you be what I would like you to be, is a person that's arguing from the heart. Your Honor, I don't need to read the book like this other side. If I see an attorney, they set the podium up and they've got the book and they read to the jury, and this is all the time, when it's my turn to go, I'll go to that same podium and move it so that now I do not have anything in front of me. So they will hide behind the podium because they're nervous, and they'll not stray from whatever their carefully prepared words say. I will pull the podium away, make a big deal in front of the jury, and I will stand there, exposed. And then I'll take my notes and I'll look at them and I will tear them in half. And I will say, ladies and gentlemen of the jury, I don't need to read from a book like my opponent. I'm going to speak to you from my heart, and that matters. People want to be talked to from the heart. Just remember the last time you were at a speech and a person was reading to you, like, you don't pay attention. You want to hear from somebody's heart. And in jury trials, that's important. Non-verbal communication is important too. How you look, like, I don't wear good suits. They are nice. They're $400 at the most with a decent tie. I don't want to look like $1 million. I will not have a handkerchief. I just look like somebody that shouldn't be representing consumers that are facing debt lawsuits. I just want to be approachable. Well, that's a non-verbal thing you're telling the court. Just like when I put a tie on with the lemons, that's a non-verbal communication. I'm here because my car is a lemon. But also, just be careful about what you say. I remember what or do at your table where you think you're safe, but you're just being watched the whole time, okay? And I remember I was picking a jury one time and we got stuck in what I look at as a closet. The judge is right on top of me, the jury is right on top of me, and my client is here, and the defendant is over there, and the plaintiff always sits next to the jury, and we're picking a jury. So I hand a yellow piece of paper from my client because he's involved in this too. I may be focused on one guy while a lady is looking at me with a horrible look on her face, meaning she doesn't like me. I won't see that person as I'm grilling this other potential jury person. So I'll tell my client, look around. And we were in a small broom closet, it felt like, but it was a jury trial. And the client, not being as aware but nervous, said to me, I don't think number 6 likes you at all. She's got this look on her face. Well, the whole place heard it. So be careful what you do and say at the table. I, being a crazy person, will set things up knowing the nonverbal of it all. In the old days when I did lemon law, I'd have a book, How to Beat the Lemon Law, right there. Consumer Law is Your Friend. I'm generally reading those books, but so is the jury. They know who I represent. So be aware of the nonverbal stuff. Be yourself. At 50, I got tired of my OCD and nonsense, and it was a battle every day. And I just got tired of it. And I also am not the friendliest person. I need to be better, and I've worked on that. People say I'm friendly and all that, but I get ornery. So I decided not to fight myself anymore. I was gonna be in jury trials and be myself. When I say be yourself, I'll give you what happened. I was in a federal court one time trying a jury case, and the clerk, old-time clerk, had been with the judge a long time, kept coming over to me during breaks going, hey, you did that good, but you need to do this, and giving me pointers. Now, as I said before, the court runs through its clerk. The clerk has all the power. The ear of the judge goes through the court staff. I wasn't gonna piss him off, so I started incorporating his tips into my trial, and I spent more time waiting for him to go as I'm doing stuff and not watching the jury. And the client said, how do you think the jury took that last piece of information? And I did not know it. So I said, oh my God, I've got to focus. And I said, I'm gonna not do what anybody else, because I get tips all the time. You should do this, you should do this. I've always been fighting myself. Once I get rid of fighting myself and being who I am, I got more bandwidth to do my job, to do my case. Like I said, that OCD stuff, that was a battle on top of everything else I got to know in that with the spinning plate. So be yourself. I mean, even if, like I know this about myself. Judges don't have much patience with me. And sometimes we go to dark places. I go to dark places with judges where they're just tired of me, especially if it's a judge that doesn't want to listen to the law and the facts, and I can't take it off my face that you clearly don't know the law. I mean, I am probably one of the guys that knows this stuff, okay? I am. I mean, you do something long enough, 10,000 hours, you're good at it. So I don't have much patience for someone that's not gonna at least give me the respect of putting a little time. And so I'll go to dark places with courts, and I want to go there. I know that sounds counterproductive, but once we are at the bottom, the judge and I, you can see the rebound. Eventually he starts to get me, and it's not that I'm a jerk. I have passion, I believe. Advocacy is 100%. You don't fake advocacy. I mean, you have a job to do, but once the judge picks up on who I really am, which is, I don't take a case I don't believe in. I believe in the law. I believe in the system of checks and balances, and they've got a right, we've got a right. You've got to protect the system to protect us all. Once they get who I am, being myself, it starts to rebound, and now it's Mr. Parker. Well, what does Mr. Parker think? But going to that dark place is sometimes tougher with court, but I have to, because that's who I am. And more than once, just once in this last trial I did, the court stopped me and said, you gotta be more civil. All right, but my passion doesn't go away. My knowledge, my ability to represent my client didn't go away, but I'm not a dummy. I just ratcheted down a bit, but as soon as I got that witness in front of me again, she's going down. And that's who I am. So those are trial tips from a personal approach. Know yourself, know the rules, know the judge, know the procedure. How does he or she like it done? Ask the court clerk. When you ask somebody a question and it's about their job or how they do something, that's a respect. So once you know how the judge likes things done. You got to ask. So there's a great checklist that's associated with this video on things you should remember to do your trial that'll make you happier and less nervous and less anxiety ridden like me, I used to be. And it will take the anxiety out of trying a case so that you can do the best job focusing while you're there, not on your nuttiness or nervousness. Once that stuff goes away, you actually kind of want to do the trial. Just trust me on that. So go to killdebt.com for the AI Superpower Parker GPT. Remember, 2.0 is coming. You're gonna love it. Remember the briefcase thing? My next videos will be checklist videos. I'm gonna give you top 10, top 15 checklists that you need to get through, starting from beginning to the end, a case. How to defend a case, how to answer a lawsuit, how to create a counter affidavit, how to do initial disclosures, how to do a pre-trial, how to make your first, all everything you need. I'll have the top checklist to go over for you. That'll be in the next video. No more of this trial stuff. I hope you don't mind. Thank you very much. Bye-bye.